Hello, welcome to Delhi Law Firm. Today we are going to discuss a very important and sensitive decision of the Supreme Court, which is highly relevant for the general public, government employees, officers associated with the Forest Department, trekking organizers, and all citizens who want to understand who bears criminal responsibility during a natural disaster and under what circumstances. This dialogue is based on a real case in which several people lost their lives tragically during a trekking expedition due to a forest fire, after which serious criminal charges were imposed on a forest ranger. The Supreme Court, after examining the entire matter in depth, made it clear through its decision that the law is driven not by emotions but by facts, evidence, and established legal principles. Today, we will explain this decision in a simple, practical, and common language so that everyone can understand the difference between a natural disaster and criminal negligence.
Absolutely. And this topic is important because after any major accident, the first attempt is often to hold a government officer or employee responsible even when there is no solid proof of actual negligence or criminal intent against them. Something similar happened in this case as well. This case is Jeyasingh versus the state, in which a forest ranger from Tamil Nadu was accused in connection with the death of trekkers caused by a forest fire. The allegation was that he permitted the trekking activity, collected fees, and sent a person as a guide, due to which people lost their lives.
Let us first understand the background of this case. In the year 2018, an organization named Chennai Trekking Club organized a trekking program on the occasion of Women's Day. Around 27 people participated in this trek. The trekking route was from Kolukumalai to Kurangini. Everything was proceeding according to the planned schedule while the group was trekking in the hills. The next day, suddenly, a massive forest fire spread across the entire region. Due to strong winds, the fire intensified rapidly and the trekkers were caught in it. Some people fell into a ditch, some suffered severe burn injuries, and unfortunately, several people lost their lives.
An important point to note is that this fire was not deliberately caused by any person. It was a natural event which in legal terms is known as Vis Major, or an act of God. Despite this, after the incident, the police registered cases against the forest ranger, trekking organizers, and others under serious provisions of the IPC, including sections 304 Part 2, 326, 338, and 304A. These sections relate to culpable homicide not amounting to murder, causing grievous hurt, and causing death by negligence.
Now the key question arises, can a government employee be held criminally responsible for a natural disaster? Can serious charges such as homicide or grievous hurt be imposed merely because the person was an officer of that area? The Supreme Court gave a clear answer to this question. The court stated that criminal liability arises only when negligence, a deliberate act, or criminal intent on the part of the individual is established.
In this case, the role of the forest ranger was limited to issuing trekking passes and assigning a local person as a guide. There was no evidence to show that he had prior knowledge of the forest fire or that he intentionally exposed people to danger. The Supreme Court clearly held that criminal liability cannot be fixed merely on the basis of a person's position or employment.
The court further clarified that Section 304 Part 2 of the IPC applies only when it is proved that the accused had knowledge that his act was likely to cause death. Similarly, Section 326 applies only when grievous hurt is caused intentionally by dangerous means. In this case, there was neither any weapon nor any intentional act. The forest fire was a natural disaster which no individual could control.
The Supreme Court also observed that in an earlier case related to the same incident, the court had already clarified that a forest fire is a case of vis major and does not amount to criminal negligence. Applying the same reasoning, the court held that there was no justification to continue criminal proceedings against the forest ranger.
This decision has brought relief to all government employees who, while performing their duties, may unknowingly get involved in situations arising out of natural disasters. The court clearly stated that if criminal cases are registered against officers in every accident, no officer would be able to perform their duties fearlessly.
At the same time, this decision also teaches the general public that it is not correct to treat every tragic incident as a crime committed by someone. The law examines how the incident occurred, whether it was beyond human control, and whether there was actually any negligence or criminal conduct involved.
In this case, the trial court and the High Court had earlier refused to grant relief to the forest ranger and directed that the trial should proceed. However, the Supreme Court set aside both orders and clearly held that when no offense is made up even at the preliminary stage, a person should not be forced to face an unnecessary criminal trial.
This decision also explains the importance of Section 227 of the Code of Criminal Procedure, under which an accused can be discharged at the initial stage if there is no sufficient material to support the charges. The Supreme Court emphasized that it is a fundamental principle of justice that an innocent person should not be harassed merely on the basis of suspicion.
If we summarize this decision, three important points emerge clearly. First, a natural disaster cannot be treated as a criminal act. Second, criminal provisions apply only when negligence or criminal intent is proved. Third, merely holding a government position does not automatically make a person criminally liable.
This dialogue is especially meant for families, young people, and ordinary citizens who want to understand how the law maintains a balance between accountability and fairness. This decision is based on law, logic, and the principles of justice, not on emotions.
In conclusion, we would like to say that the law gives every individual the right to a fair hearing and justice. If you are facing any kind of legal issue, whether it is a criminal matter, a family dispute, or any other legal concern, seeking expert legal advice is your right.
You can contact us from any state across India for the resolution of your legal problems. Our team has experience in handling a wide range of legal matters.
To contact us, you may visit our website www.delhilawfirm.news. Delhi Law Firm always stands with your rights and is committed to guiding you on the path of justice.